The internet. It's strange to think that we don't even really know when it started, but it used to fit on a single computer.
Would we have been nearly so excited in the mid-90s when we unboxed the consumer internet, given all the bad stuff that we now know also lurked inside? Like Pandora, we must all make our own balance sheet of its contents, of the good and the harm.
It is a complete accident that the internet looks and feels the way it does, a sort of lawless Wild West where people can say and do more or less anything they want. It's certainly not what the politicians had in mind. However, a tiny clause in one law passed in the United States 20 years ago more or less props up the whole thing. Internet freedom has always been controversial, but now there's more pressure than ever to reform this law, with profound, perhaps even chilling, consequences for all of us.
I think we're at a really dangerous moment for free expression online.
There are, politicians responding to public concerns say we must do something, and what they do is not clear.
And the tech companies are realising they have to act, and if they don't act, the danger is for them that governments will start to legislate.
In the early 90s, the reaction of many lawmakers to the internet was pretty much this.
It's not exactly homework. Oh? It's the internet. What? Oh, turn it off, Claire, turn it off. I've heard about this internet. It's a corrupting influence. I saw a programme about it.
In the United States, Congress passed the Communications Decency Act in 1996, which, as its name suggests, was all about keeping this new online world clean. But the US Supreme Court struck down most of its restrictions. One clause, uncontroversial at the time, Section 230, remained. It says no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider.
This is unique. No other jurisdiction in the world has such a sweeping immunity for online services. The US is home to some of the largest interactive computer services in the world, and I don't think that's a coincidence. Section 230 has played a very active role in fostering the growth of social media, search engines, consumer review sites, because there is sort of this almost laissez-faire attitude toward user content because of Section 230.
At the time, hardly anyone understood the implications of 230. It was actually just an adaptation of a law that protected bookshop owners. It was argued that they couldn't be expected to read every book they stocked, so it would be unfair to prosecute them for something written in one. But in the case of books, of course, there are publishers who can be sued, and they therefore act as gatekeepers. What the framers of 230 completely failed to appreciate is that on the internet, the barriers to publication would disappear. There would not only be no gatekeepers, there'd be no gates.
Everything from eBay to Facebook to Airbnb to Twitter to TripAdvisor to Google, they all rely on Section 230. It's the ultimate backstop that protects them from prosecution. And it's the ultimate reason why seemingly independent sovereign countries like the UK can't pass laws on their own to rein in the tech giants.
We can certainly try to do it. I mean, Facebook and Twitter, they have offices in London providing services related to the provision of the Facebook service and the Twitter service. So we can certainly put pressure on these companies, but ultimately, were they to want to continue to provide services and avoid UK regulation, there is the potential that they could simply withdraw back to the United States.
As if to demonstrate this legislative weakness, tomorrow a committee of MPs will hold an evidence session in Washington.
This is something that's never been done before, to have a live select committee hearing in another country. But what it's meant is, because the tech companies themselves are headquartered in America, it's giving us access to people that are involved in the global policy decisions those companies make, not just the people from the UK that represent them.
The committee is looking specifically at fake news. Like many of the big internet problems we struggle with, it has its origins in Section 230, which treats online companies as platforms, not publishers. The Select Committee chair says regulatory reform is long overdue.
I think we need to come up with a new definition that is some way between a social media company being a pure publisher and simply being a platform, to recognise that they have a responsibility to police and manage their platform in a way that restricts the harm that some users can cause and create. And I think it's our job to identify what we think the social problems are that the social media companies need to act against.
In the US, many politicians are in a similar place, but the difference is that they can be legislatively effective.
Do you acknowledge today, for the record, that child sex trafficking is a serious problem on Backpage?
After consultation with counsel, I decline to answer your question.
What's triggered the debate there is the case of Backpage, an online classified advert site that was found by a Senate investigation to have knowingly run ads for children who'd been trafficked for sex. But the law apparently couldn't touch Backpage because of Section 230. Legislation is currently going through Congress to change that.
I think if we don't address this issue with a targeted exception, I think that Section 230 could be in jeopardy down the road altogether. What I would rather see is a targeted exception that actually prevents sex trafficking and still preserves the enormous free speech and innovation that Section 230 promotes. And I think that's possible. I think if we don't address this issue, I would be very worried that that could cause more sweeping changes to Section 230, which I think would be very dangerous.
But there is a worry that once Section 230 is chipped away at, it won't end there. They might start with laws to restrict sex trafficking, but the politicians would soon come back for more. There is already an appetite to restrict the right to publish what's known as fake news.
People have the right to speak their mind, and no one can get into the business of censoring opinion. People can have wildly different opinions on the same event, but as long as that event is true and based on fact, that's fine. I think we have to take a stand where people are spreading harmful content that is based on lies.
So the social media companies are increasingly under pressure to decide what's true and what's false, what's legal and what's illegal. And the algorithms they will use will of necessity be blunt, sweeping and cautious.
If you think about the sheer volume of content being uploaded onto the internet on a daily basis, it's just impossible for internet providers to be able to effectively decide what is illegal and legal content. And I think we're just going to end up in a situation where jokes, where perfectly legitimate content, even controversial content that we might find distasteful but ought to be there as part of a free and open internet, is simply removed.
So the barriers to ordinary people publishing might go up again, and the internet become more like TV or newspapers with one-way communication. It may be that we'll see this chaotic free-for-all of the last couple of decades as a mere blip in human history.